Good morning, everyone. Good morning. Welcome to Assembly Judiciary. Those here in Carson City, as well as anyone in Las Vegas or those people viewing online through either Nellis or our YouTube channel. With that, Secretary, will you please take the roll?
Assembly members Cole. Here. Dahlia. Here. Gonzalez. Here. Gray. Here. Hanson. Here. Hardy. Here. LaRue Hatch. Here. Marzola. Here. Moore. Here. Nadeem. Orant Liquor. Here. Roth. Here. Urick. Here. Chair Miller.
Here, thank you. Just a few housekeeping issues before we get started. Again, it's always a good reminder that we all turn down the volume on all of our electronics as to not be disruptive. Again, the agenda and everything's available on Nellis. On the agenda, you will also see the phone number to call in. If you choose to make public comment over the phone, we will have a public comment section at the end of today's meeting. You also are more than welcome to submit your comments in writing to the committee as well, which you can email. When testifying, as well as presenting or responding to questions, please make sure that you say your name and spell it for the record, and also give your affiliation. That way we can have accurate notes in the minutes. With that, today we have two presentations. And so I will begin with an overview of the State Board of Parole Commissioners. And so I'll give you a moment to get settled in. Happy Friday, everyone. We're coming down to the closure of our first week in session. Is it just a week? I didn't say it felt like a week. I said it chronologically is a week. So I don't want the presenters to feel pressure like you're the one standing between us and the airport, but I'm just, yeah. But with that, with saying it, again, we ask that it's always, better if we keep our presentations to 15, 20 minutes, because again, that way we can allow enough ample time for members to ask questions. So with that, if you're ready, please proceed.
Good morning, Chair Miller, Vice Chair Marzola, and all members of the Assembly Judiciary Committee. My name is Chris DeRico, and I'm the Chairman of the Board of Parole Commissioners. Thank you for allowing me this opportunity to provide you with an overview of the Parole Board. The Parole Board, the Board of Parole Commissioners consists of the Chairman and 6 Commissioners. We are all appointed by the Governor and appointed to 4-year terms. I have been with the Parole Board since August of 2017, and I've served as a chairman since July 2018. So what is parole? Parole is a conditional release from prison. At a sentencing hearing, before an individual is confined to prison, a district judge will impose both a minimum and maximum term of imprisonment. After an individual enters the prison system, the Department of Corrections runs calculations to determine when an inmate will be first eligible for parole. The Department of Corrections are the timekeepers, not the Parole Board. Once an inmate is eligible for parole, they are placed onto an eligibility list, and we schedule and conduct the hearing. Parole is an act of grace, and there is no right to parole. The Parole Board is primarily responsible for making decisions to either grant or deny parole. We make parole decisions, and favorable decisions are passed on to the Division of Parole and Probation, who investigate release plans and subsequently supervise the cases. We also conduct parole violation hearings, where we determine whether to revoke a parolee's supervision and return them back to prison, temporarily revoke their parole supervision, or to reinstate them back to the community. We are an independent body. If you look at this organizational chart of the Department of Public Safety management team, you will see that we are included with them. However, the Parole Board sits off to the side, and we are not connected to their tree. We work closely together, and they provide administrative support to us, but we are an independent body. This is the Parole Board's organizational chart. We're a small agency with 2 offices, one in Carson City and one in Las Vegas, with 28 full-time employees. The chairman oversees the executive director and the operations of the entire office. Additionally, the Parole Board assists the Pardons Board. The Pardons Board consists of the Governor, Attorney General, and the Justices of the Supreme Court. The Parole Board houses the Pardons Board Executive Secretary, who also has one assistant. If an inmate is granted parole, the Division of Parole and Probation provides parole supervision. They do this by monitoring the parolee's residence, employment, activities, associates, along with many other duties. The Parole Board does not have parole officers under it, and these supervision services are provided by the Division of Parole and Probation. We are two separate agencies. Conditions of parole may include drug testing and treatment, residential confinement, no contact with victims, or requirements to pay restitution, just to name a few. The Division of Parole and Probation enforces the conditions as ordered by the Board. The Parole Board is part of the judicial system. Statutes give us our marching orders and tell us how and what we are supposed to do. The Parole Board offers the system some flexibility. It is not black and white. The court imposes a minimum custodial term dictating when an inmate may first be considered for parole. The Parole Board then may grant parole at any time between the minimum and maximum imposed term of incarceration within statutory limits. In making these decisions, the Parole Board needs to consider many things, particularly whether an individual can be safely supervised in the community prior to the expiration of their sentence. It takes 4 commissioners to affirm a decision to grant or deny parole. It is never one person deciding anyone's fate. We conduct many types of hearings at the Parole Board. A discretionary hearing is exactly that. It's at the discretion of the Board. When the Department of Corrections notifies us that an inmate is eligible for parole, the Board will schedule and conduct a hearing to determine if it is appropriate to release a particular inmate back into the community with parole supervision. Mandatory parole hearings are generally conducted if an inmate was not granted parole at a discretionary hearing, and it's the last chance to get out of prison a little early with supervision. Mandatory parole is set by statute, and the primary consideration is whether the inmate is considered a danger to public safety. While there are many different considerations in a discretionary hearing, the primary concern for mandatory parole hearings as set by statute is public safety. The Board can also conduct geriatric parole hearings for qualified inmates. To qualify, an inmate cannot have been convicted of certain types of crimes, violence, crimes against a child, sexual offenses, or vehicular homicide, nor do they qualify if they've been found to be a habitual criminal. Inmates must be at least 65 years of age and have served a majority of the maximum term of the sentence. The Board also conducts reconsideration hearings. An example of this is when an inmate who was granted parole but not yet released is subsequently found guilty of a major violation of prison rules. The Board will conduct a reconsideration hearing with the inmate and review the details of the violation and determine whether the violation was serious enough to change the previous decision to grant parole. The Parole Board regularly conducts parole violation hearings, which result in either a return to incarceration, a temporary revocation of parole supervision, or a release back to the community to satisfy the previously imposed requirements of parole. If a parolee is found guilty at a parole violation hearing of committing a certain misdemeanor, gross misdemeanor, or felony offenses, absconding from supervision, or termination from a program indicated in a parole release plan, the Parole Board may revoke parole supervision for an amount of time as authorized by statute. However, if a parolee is found guilty of technical violations only, the Board may temporarily revoke parole supervision for a shorter period, 90 or 180 days, and then have the parolee released back into the community with credit for any time served. The Board also conducts early discharge hearings, and a parolee must meet certain requirements to qualify, and the Division of Parole and Probation initiates this process when appropriate. Lastly, the Board conducts lifetime supervision hearings. Lifetime supervision is imposed upon certain convicted sex offenders after they have completed the statutory requirements of their underlying offense, either through probation, parole, or completion of a custodial term. These offenders have an additional term of supervision of at least 10 years to life, and they are supervised by the Division of Parole and Probation. The Board, by statute, is required to to set these supervision conditions. Looking at NRS 213.131 subsection 3, which was written many years ago, it states that meetings to consider parole may be held semi-annually or more often. I can tell you that the parole board generally has hearings scheduled every day of our work week in both Las Vegas and Carson City. This slide also reflects our actual numbers for fiscal year 2024. In fiscal year 2024, the parole board made 6,039 actionable final decisions. Each of these final decisions required a minimum of 4 votes to ratify, which equates to approximately 24,156 decisions entered by commissioners in the last fiscal year. If you include all hearings, even those that did not result in a final parole decision, we held 6,836 hearings during fiscal year 2024. We have 4 hearing rooms, and when necessary, we use all 4 hearing rooms at the same time to meet our obligations in a timely manner. This slide shows our actual caseload numbers beginning with fiscal year 21 through projected fiscal year 27. The projections were taken from the James F. Austin Institute, JFA, Winter 2023 forecast. We were recently informed that Justice Planners is the new contracted vendor for the state, but we have not received any updated projection report from them yet. The figures for fiscal year 2025 are, I'm sorry, I went one slide ahead. The figures for fiscal year 2025 are based on 6 months of actual hearings, 3,261, to include discretionary, mandatory, and violation hearings. Additionally, projections show that our second half of this fiscal year will result in approximately 2,546 more hearings, and these hearings include all parole-related hearings. The violation hearing projections assume that there will be a 2% increase in parole violators, and these assumptions were based off the JFA prison population projections encompassing the years 2023 to 2034. This chart shows 4.5 fiscal years of parole hearings by general offense type as defined by the Department of Corrections. We have included the actual numbers for the first half of fiscal year 2025 on the chart as well. What we are seeing now in the first half of this fiscal year is a small increase in the caseload over the past year. You can see that if we continue with this trend, we will conduct approximately 4,736 actionable parole hearings by the end of this fiscal year. Of note, these numbers do not include violation hearings, continuances, or hearings that resulted in no action. As previously stated, if an offender is found guilty at a parole hearing of technical violations only, there is an incremental temporary revocation of parole supervision period that must be imposed, followed by release back into the community. In the last legislative session, AB 32 removed the 30-day temporary revocation period, and a technical violator must now progress through the 90 and 180-day temporary revocation of parole supervision period before statute authorizes the board to fully revoke an individual within statutory limits. A temporary revocation of parole supervision does not apply if an offender has been found guilty of certain new crimes or if they've absconded from their parole supervision. This chart details the number of first temporary revocations of parole supervision for fiscal year 2024. The statistics on this page only reflect temporary parole revocations and those with violations that rose to a higher level, such as the commission of a new crime or if they have absconded from supervision. This chart details the number of temporary revocations of parole supervision for the first 6 months of this fiscal year. Once again, the statistics on this page only reflect temporary parole revocations and not those that rose to a higher level, such as the commission of a new crime or if they absconded supervision. In closing, even though we are small, our impact on the state is large. Our primary role is to conduct hearings and make decisions whether to grant inmate releases to the community under parole supervision or to deny those inmates that may pose a risk to public safety. Certainly the cost of community supervision is significantly less than supervising individuals in an institutional setting, and our commissioners and support staff are very well aware of this. Our staff works very hard to do what we can to serve the best interests of all citizens in the state of Nevada. And if any of you would care to spend a morning or afternoon with us observing hearings, feel free to contact me and I'll make sure to set that up. Lastly, our website address is on this slide. Additional information can be found here. Thank you for allowing me to present to you today, and if anyone has any questions today, down the road, please feel free to contact me. Thank you.
Thank you so much, and thank you for such a concise, informative presentation. And also, I appreciate you defining what parole is in the beginning, because like any other committee, we often come in from all kinds of different educational and professional backgrounds. And like if you were watching so far this week, there's acronyms and every committee being thrown around. And so I really appreciate you, because we assume that everyone knows at the most basic level. So I appreciate that definition for you. We, of course, do have some questions for you. We will start with Assemblymember Ornlicker.
Thank you, Chair, and thank you, Commissioner, for the presentation. My question is about the geriatric release. You listed a number of criteria. Are those statutory, or have you, as a commission, developed them?
Chair, may I respond direct?
Please go direct.
Thank you. Assemblyman Ornlicker, those are all in statute.
And concise answers. Wow, yes. Thank you.
You did say something about Friday flights, so.
So apparently we're not the only ones, right? Our next question is from Assemblymember Roth.
Thank you, Chairman. Nice to see you this morning. My question is in regards to AB 32, which was passed last legislative session. I think that there's been a lot of really good work coming from your commission on issues regarding release. One issue that I have seen is in regards to graduated sanctions. So when we talk about the technical versus non-technical violations, and when we can actually place someone back into custody, one requirement in AB 32 was to ensure that parole and probation was implementing graduated sanctions that were being recorded properly. And it's my understanding that that's not always happening. So what education piece does your commission engage in to ensure that both parole and probation and your commissioners making those decisions are following the new implementation of AB 32?
Thank you for that question. So as you're well aware, AB 32 places that onus on the Division of Parole and Probation to make the determination whether or not they have imposed or gone through their graduated sanctions. That is something that is on them. And so when they come before us, they, as statute says, they develop their own graduated sanctions in the program, and they determine when they have gone through them. So we can't, so to speak, tell them how to do what they have determined are their or belong in their graduated sanctions matrix. They develop that. We have nothing to do with that. So when they determine that they have gone through their graduated sanctions, and that it gets to a point where they might request a warrant or to have a parole violation hearing, then that's at their determination per statute right now.
Please.
Thank you, Chair. My follow-up question would be then in regards to oversight over that. I think that I disagree with how I read the law as far as the parole commissioners are responsible for determining whether or not parole and probation has met the requirements for the commissioners to then place somebody into custody. And so, my concern remains, what oversight is there over the commission outside of ridding the Supreme Court?
Thank you for that question, Assemblymember Roth. So I think this is where there might be a difference of opinion, because statute clearly says that the division that is their role. Once the division has determined that they have exhausted their graduated sanctions. So it's not the parole board, and I think you mentioned the commission, meaning us, but the parole board. So we don't have anything over that. I would suggest potentially, if there was an issue with regard to the graduated sanctions and and how they might be applying or interpreted or their matrix, I would suggest reaching out to the Division of Parole and Probation to see if there's something that they can do, because that is what is listed in laws as for them to develop and determine whether it's been run through.
Thank you for that. Our next question is from Assemblymember Hardy. Okay, I read that wrong. Our next question is not from Assemblywoman Hardy, from Assemblywoman Hanson. I knew it was one of the members with an H, yeah.
Thank you, Chair, with the M. Good to see you. Thank you for the really good overview. I'm embarrassed to admit I have not taken you up on the offer to come and attend some hearings, and that's what my question is in regards to. So I will reach out and hopefully be able to attend some of those. When it comes to just the logistics you mentioned, you'll have simultaneous hearings going on because it sounds like the load is pretty heavy. It takes 4 votes. So I'm just looking at the chart on slide 6. So you have hearing examiners, but you have to, do you have to have all of the 6 plus the chairman at every hearing? I was just wondering, how do you do hearings at the same time?
Thank you for that question, Assemblymember Hanson. So we have hearings. There are certain hearings by statute where we have to conduct them with at least 3 commissioners. Okay, your murders, your habitual criminals, certain sex offenses, all the serious crimes have to be conducted with 3 commissioners. Aside from that, we can conduct with 2. So when we have parole hearings, there will be 2 individuals on the panel generally conducting the hearings, except for those serious crimes that are laid out in statute. And then with that, so they'll be the panel, they'll make a recommendation, and then once it's reviewed by the rest of the board, then a final determination is made. And just to follow up on your statement, yes, our hearings are generally north and south. Start at 8:15 in Las Vegas and Carson City, Monday through Thursday, and then the second block starts again at 1 p.m. as well. So generally every day of the week. So we have a lot of hearings to get through, and we want to make sure we're hearing those in a timely fashion and that no one's sitting past that eligibility date. We have no backlog. We make sure that if anybody's eligible to be heard, they're heard.
Thank you for that question, Assemblymember. So just to clarify, you're saying that the decision would be made off of 2 commissioners?
Thank you, Chair. No, that's not correct. So you
Okay.
would have 2 individuals on a panel that would make a recommendation to the full panel, but then once that's reviewed, it does take 4 of the 7 commissioners to either grant or deny that parole.
Okay, thank you so much for that clarification. Thank you. Not seeing any other questions. I thank you so much for your time and your presentation. I know we'll see you back again in this room. So with that, I will go ahead and conclude this presentation. Thank you. Our next presentation today comes from the Office of the Public Defender's Office for both Clark and Washoe. So I will let everyone approach and get settled, and when you're ready, introduce yourselves, please, and then proceed.
Good morning, Chair and members of the Assembly Judiciary. My name is Paloma Guerrero, that's P-A-L-O-M-A-G-U-E-R-R-E-R-O, and I'm here with my boss, Assistant Public Defender John Pirro, and we are the Clark County Public Defender's Office. I want to start with this video that encapsulates the work that we do. And it doesn't have sound. Now, it's easy to focus on a single point in time. One moment, one mistake. That kid is late. That kid is late to school every day. And he's punished for it, and he still continues to make the same error over and over and over again. And we, as public defenders, we try to paint the whole person. We try to paint the whole picture. And we present that, the whole picture, not as a defense or an excuse or a justification, but to explain the why, because context matters. Context is important. And we're talking about the moral culpability of a person. The context is important. When we watch this video, the kid is late, the crime is being late, and the kid is guilty. But when you learn the why, when you learn the whole picture, you learn that that child is taking on a responsibility that no child should. And that perfectly encapsulates the work that we do as public defenders. Now, this legislative session, we are very lucky to have two amazing interns. We have Harrison Epstein from the William S. Boyd School of Law, the best law school in the state of Nevada, and he's in his second year. And we also have my 5-month-old puppy, Kira, who will be providing extremely important and necessary cuddles and kisses this session. Now, in case you don't know what a public defender is, it's an attorney that's been appointed by the court to represent somebody in a criminal matter who can't afford an attorney. And 85% of people cannot afford an attorney. And the question that we get asked most often is, how can you do that work? How can you defend somebody that you know is guilty? So that's why we're starting with this quote that I think really drives our practice, which is, love is the motive, but justice is the instrument. And I asked an attorney from my office, Chris Giddens, what being a public defender meant to him, and this is what he said. For me, being a public defender means getting the opportunity to ease suffering, no matter the judicial result, with how I treat others. It means demanding that people be properly seen and their story told. It means believing in treatment and rehabilitation, compassion and understanding, hope and redemption. It means being surrounded by inspiring and supportive coworkers who light the way out of dark times. And there are dark times. We do this work because we love this work and we love our clients. And what we do every day is stand up for the Constitution in our courtrooms. We advocate for the rights of the accused. And I don't know how many of you have seen the play Hamilton. If you haven't, it's really amazing. You should watch it on Disney+. But Alexander Hamilton, defense attorney. Aaron Burr, defense attorney. John Adams, defense attorney. So we're really carrying out the intent of our founders with what we do every day in the courtroom. And when I was in the assembly chambers, watching all of you introduce your families to all of us, I noticed that there's a portrait of Abraham Lincoln. Abraham Lincoln was an incredible attorney, and he famously defended a murder case and won using the Farmer's Almanac as an exhibit. And this is our office in Clark County. We have the first ever female public defender, Nancy Lemke, who is an incredible leader in our office. We have 129 attorneys. We are down by 7, but all for good reasons. We have had attorneys that have retired after 30 years of servicing our community, and we have also had attorneys who have ascended to the bench and are choosing to serve our community in a different way. And these are the different teams that our office is split up into. And I do want to highlight our mental health team because, as we all know, we have a severe mental health crisis in Nevada. The Clark County Detention Center is the largest mental health provider in the whole state. 1/3 of the CCDC population is on psychotropic medication. And the wait times for people that have to go up to competency are extremely long. So when somebody is found incompetent, that means that they are too mentally ill to understand what is going on. And they have to be transferred over to a state-run mental health facility to get treatment. But before they get there, they just have to sit in our jails and wait. And they sit and wait without any sort of mental health treatment or services. So they are sitting in our jails at a cost of $200 a day per person to the taxpayers. And it's an extremely dangerous place to be. We have had a client of ours who was murdered while he was waiting to get treatment. Our client was in a cell with another mentally ill person, and that other mentally ill person murdered them. And that death just should not have happened. We also have 79 non-attorneys. We have social workers in our office, investigators, mitigation specialists, and all of our support staff. They are really there working in tandem with our attorneys to ensure that we are meeting our clients' needs. And they're also there because we aim to practice what's called holistic defense. Because we don't want to just address the court case, we really want to address the circumstances that brought a person to be one of our clients. And the gold standard for this is the Bronx Defenders. At the Bronx Defenders, they have eviction attorneys that help people with their housing issues. They have family law attorneys that help people with their family law concerns, because the model understands that a person can have more than one issue going on that's becoming a barrier to their success. And if you have somebody there that's guiding you through each process, then that's going to lead to less recidivism. It's going to lead to less time in jail, and it's really going to result in better outcomes for that person and for their families. So that's really the gold standard here, and that's what we aim to be, but we still have a long way to go. And I do want to share with you a story of a client of mine. We'll call him Michael. One of the first things I go through with my clients is try and see if there's any sort of substance abuse issues. And I asked my client if he did any substances, and he said yes. I asked him what, and he said meth. I asked him when the first time he tried meth was, and Michael told me 12 years old. Michael was now 26, and I asked him to tell me more. Michael was the oldest of 5 children. His father had died when he was very young. His mother had boyfriend after boyfriend after boyfriend, and Michael saw those boyfriends abuse his mother. And being the oldest of 5, anytime his siblings misbehaved, it was Michael's fault and he was punished. So at 12 years old, he tried to spend as little time at home as possible. So he couch surfed at friends' houses, couch surfed at relatives, but sometimes he wouldn't have a place to go. So he would just walk the streets of Las Vegas at night. And being on the streets is when he was first offered meth. And he found that meth kept him up. And if he was up, he didn't have to worry about a place to sleep that night. Because that was better than being at home. And I do want us all to think about just how easy it is for somebody to succumb to addiction, because that was really hard for me to understand as somebody that doesn't battle with that issue. But if your life is so difficult that the one chance you get to escape it is when someone offers you drugs at 12 years old, and it's the first time in your life all that pain and suffering goes away, then it becomes a little bit easier to understand. So I had my social worker talk to Michael. We assessed his level of care, and we got him into drug court. Drug court is a specialty court. Specialty courts are being smart on crime. They are helping people. 77% of people who graduate from a specialty court do not recidivate. And we see that even if somebody just gets put into those specialty programs and doesn't get to graduate for whatever reason, they are still less likely to recidivate when they've had some form of treatment. Now, if we look at our case
So
numbers,
I'm just gonna briefly ask, because again, we try to be consistent in here. If you could get us more specifics about Clark County's office. Thank you.
yes. These are our caseload numbers from the last 2 years, and if we look at this, they closely mirror what we have seen this whole entire week, which is that crime is trending downward. In Clark County, we practice what's called vertical representation. That means that when I'm assigned to be your attorney, I'm your attorney till the final destination. Challenges facing our office, like every public defender in the whole nation, we have very high caseloads. But I do want to talk about just the fact that we do need more community resources. That's the path to being smart on crime. We agree with what John Jones from the DA's office said yesterday. We need more options for drugs and mental health treatment. And we need it before people come into contact with the criminal system, because it's a sad fact that you can get more resources after you've been accused of a crime. Like we talked about, our mentally ill population is growing. And again, what we really need is resources for real rehabilitation for Nevadans before they come into contact with the system. And Kevin McMahill, our Clark County Sheriff, has said this himself. We cannot incarcerate our way out of our community's challenges. And we heard from Director Zarenda this week, the prison population is growing, and that's a problem. Father Gregory Boyle says the best cure for crime is a good job. It's access to healthcare, it's access to education, it's access to affordable housing. It's being smarter on crime. It's not putting more people in jail. Now, in late 2023, a bunch of community stakeholders that were PDs, DAs, reps from Metro, they all went to Miami-Dade and studied the Miami model there. And that's because they've been extremely successful. They have reduced their crime, have diverted low-level offenders, have stood up mental health resources, and have invested in the community. And these changes have led to tangible differences. They closed down a whole jail facility, and that is saving them $120 million a year. They are getting people into mental health and drug treatment sooner, and that has led to fewer people in the jail and more people getting treatment. And what's really astounding is that they have lowered their homeless population from 8,000 to 1,000. And that is because of measures that they've taken that are smart on crime, like we have passed here in AB 236. And we just need to keep moving in that right direction. So this is a big reason for hope that we have a model that has been successful that we can imitate. Being smart on crime works. Following evidence-driven practices work. In 2019, before Nevada passed AB 236, Nevada was trending in the wrong direction. We were incarcerating at a 15% higher rate than the surrounding states. And lastly, teamwork makes the dream work. Like Captain Martinez said for Metro, everyone working together is helping. Community engagement is helping. In Clark County, we have the Criminal Justice Coordinating Council, and we're currently trying to implement all of the things that we learned from Miami, but we do need the legislature's help. And I want to leave you all with some celebrity public defenders. And if trends hold, Assemblymember Roth could be our next Speaker of the House. And thank you so much, and I'm very, very excited to be here.
So with that, we're going to go ahead and let Washoe present as well. And if you could, while you're presenting about your office, just because we sometimes when the two different counties, and I'm not leaving out the other 15 counties, but when Clark and Washoe, sometimes it's helpful for us to learn the contrast too. So we know there's a lot of similarities, but if you could just kind of keep in mind, otherwise we'll ask at the end, maybe if there's any differences as well. And then we'll take questions at the end, and you all are welcome to jump in and respond, so.
Thank you, Madam Chair, and good morning, Assembly members. My name is Angela Knott, and that is spelled ANGELA-KNOTT. I am a Deputy Public Defender with the Washoe County Public Defender's Office. Next to me today is Evelyn Grosnick, and her name is spelled EVELYNGROSENICK, and she is the Public Defender of Washoe County. The mission of the Washoe County Public Defender's Office is to protect and defend the rights of indigent people in Washoe County by providing them access to justice through the professional legal representation. Most people accused of a crime have a right to counsel. This includes people accused of misdemeanors, gross misdemeanors, or felonies. When a person cannot afford private counsel, our office or the Office of the Alternate Public Defender will be assigned to represent them. The Washoe County Public Defender's Office is the largest provider of indigent defense in northern Nevada. Since the 2023 session, our office has had a slight increase in staffing. This is a place where we differ from Clark County, and we are about half the size of Clark County. We do now have 78 employees, including 47 attorneys. Our office is divided into 5 main divisions. We have the criminal division, the family and mental health division, our youth defenders, our appeals team, and our support staff. We do have 2 notable changes since the 2023 session. We have added what's called the Complex Litigation Unit, and we now have a competency court at the 2nd Judicial District Court. The Complex Litigation Team, which I am a part of, was implemented last month. We took the previous Category A felony team, which was mainly sexual assaults and murders, and we have expanded it. We now include Category A drug trafficking cases, kidnappings, and the more serious attempt crimes. Also, as we will discuss a little further, we now have a competency court in the 2nd Judicial District Court. Our clients in competency court are represented by our Chief Public Defender, Jennifer Rains. So what do we do at Washoe County Public Defender's Office? We provide an effective voice for vulnerable populations. We protect the rights of individuals for the benefit of all. And we have a holistic representation to reduce recidivism and promote a strong and safe community. Part of our holistic representation of clients includes utilizing social workers. We have 2 full-time social workers, and we're in the works of hiring another one. We also have social work interns who help us throughout the year. These social workers help us humanize our clients. They find our clients' stories. They explore their backgrounds and their families, their economic status, the relationships that they have, and any behavioral health issues or other avenues to help tell their stories. We want our clients to be known for more than just a defendant. These are people. As we heard from the Washoe County Sheriff's Office on Wednesday, crime rates are decreasing, and this is a good thing. However, in Washoe County, we are seeing an increase in the number of cases being set for trial. The increase in the number of trials being set is causing congestion in the courts and delays in justice. But even with the delays and the increased workloads, we are progressing in finding alternatives to incarceration. One way is by the creation of the competency court. These are the statistics from the Nevada Crime Stats Online. As you can see, property crime statewide and in Washoe County is down. The same for violent crime. It's down in both statewide and in Washoe County. These are the 5-year trends for violent crime, and we provided the 5-year trend for property crime. This chart, it contains the number of trials that were actually tried in these past years. The orange line that you see in the graph, that is when the Washoe County District Attorney's Office initiated their plea policy. That was in the beginning of 2023. I would like to note for you all, that number on 2023 says 68. That is actually the number just through September of 2023. By December of 2023, that number was actually 94 trials that went in 2023. And as you can see, it maintained in 2024 with 93 trials. So while there has been a noticeable increase in trials, the Public Defender's Office has stepped up, and we have stepped up and met the challenges that we needed to. And we do want to take a moment to thank Washoe County because they help provide us with effective with what we needed to provide effective and zealous representation of our clients, despite the increase in trials and workloads. Defendants have a constitutional and statutory right to a speedy trial. That means trial within 60 days of arraignment. However, that is not happening with the congestions in the court. Courts are triple booking trials. Speedy trials are being set well outside the 60 days, and we're not talking days of delay, we're talking months. This impacts not only our clients, but impacts Washoe County financially. It costs anywhere between $160 and $800 per day to house a defendant at the Washoe County Jail. Now to progress. AB 236 addressed Nevada's rising prison population while promoting more effective, evidence-based approaches to public safety. We hope that this legislature continues the important work started by this legislation. In the spirit of AB 236, Washoe County and other agencies came together to create a competency court in the 2nd Judicial District Court. In competency court, we are taking steps to find alternatives to incarceration and to help those who suffer from severe mental health issues, but find themselves stuck in the criminal justice system. These are all the stakeholders of the competency court. We are working closely with each agency to ensure that each individual client is being assessed. We are coming together to solve an issue. We are hoping for more of this collaboration. Even though the competency court is relatively new, we are already seeing progress. With the limited existing resources that we have, we're trying to do more with joint considerations for alternatives to incarcerations. The high-cost services of the Washoe County Jail, Lakes Crossing, and the prison system is not the solution. We want to transition to more cost-effective services that help treat the underlying behavioral health issues. This is what's called the sequential intercept model. This was presented a few weeks ago at the Washoe County Board of County Commissioners. This model is a widely accepted conceptual framework that identifies key points within the justice and behavioral health systems to intercept individuals before they penetrate deeper into the system. Incarceration does not treat behavioral health issues. Instead, these individuals need evidence-based treatment. The question posed by this model is, how do we get the right services to the right people at the right time? The primary purpose of this model is to prevent criminalization of behavioral health challenges and promote collaboration between justice and behavioral health systems. As you heard from our colleagues in Clark, community resources are essential. I've highlighted substance abuse treatment facilities, mental health services, and supported housing. Those are three main areas that we will be watching this legislative term. The default response to a mental health crisis should be with a mental health professional, not law enforcement officers. We need to invest and transition to behavioral health responses that are evidence-based and promote long-term recovery and community safety. One way to accomplish that is through supportive housing. Supportive housing is one alternative to incarceration. Not only does supportive housing help the individual and the community, it's cost effective. 1 year of supportive housing is equal to 4 months in jail or 8 days in a hospital. These are the types of alternatives to incarceration we are exploring. In summary, we are making progress. We are starting to think outside the box. We are trying to find alternatives to incarceration. There are challenges to providing effective representation to our clients, but we are facing those challenges head on. Our office strives to protect the constitutional rights of those accused of crimes. Thank you.
Thank you so much for that. And I'll also say to both counties, thank you for, again, just like in our previous presentation, defining some of these most basic terms and concepts for us. That's very helpful for everyone. With that, we do have a few questions. I will start with Assemblymember LaRue Hatch.
Thank you, Chair, and thank you both for being here today. My question is going to be Washoe specific because that's where I live and that's what I know the most about. So we heard a little bit about the new plea policy for the DA's office yesterday, and I know you mentioned it in your presentation, but can you just explain to us from your perspective how it works and the impact it is having on your day-to-day and the trial loads and the backlogs and all of that?
Evelyn Grosnick, for the record. Thank you for that question, Assemblymember LaRue Hatch. Under the plea policy, defendants are generally expected to plead guilty to the highest charge or go to trial. The state does have a policy, the county does have a policy of pursuing the habitual enhancement in every possible case. And while the plea policy does talk about the possibility of a line deputy going to a supervisor to ask for permission to deviate from that policy, we see that not happening in a lot of cases. I think the thing to remember is that the policy may sound one way on paper, but does not always play out that way on the ground. And what we see, what the results of that, the practical results are, we have a system that is built on assuming that the district attorney's office, the prosecuting agencies will use discretion. And they don't always use that discretion. And a plea policy takes that discretion away from the line deputies, who are the ones who know the case the best. And what that means is the video that you saw from my colleagues, that backstory about why that child was late to school every day, that's the equivalent of what's going on in our clients' lives. Should we be treating individuals who it's their first possession of 0.8 grams of meth, should we be going to trial on a felony because they're expected to plead guilty to that? Or should we use our resources in the justice courts to see if we can get them into treatment, see if we can support them and help them through that process? So cases that were formally resolved as misdemeanors, gross misdemeanors, or lower level felonies are less frequently being resolved that way. The Reno and Sparks Justice Courts both have very robust treatment programs and specialty courts that we feel are being underutilized, and more cases are going to the felony courts. Now, many of our clients receive the opportunity for specialty court in the district court. However, those specialty courts are becoming full, and people are being turned away because there is not room for them. I just want to emphasize as well the effect on a community of increasing the number of people who are adjudicated as felons. It's creating a community of individuals who will struggle to find housing, who will struggle to find jobs, who will struggle to take advantage of important benefits that not only impact them, but their families, their children. And many of you have practiced criminal defense or are familiar with it. You know, every case is different, every person is different, and those things should be taken into account in the criminal justice system. I do want to emphasize that we work together a lot with the district attorney's office. They have, I think, done incredible work in our competency court, in our specialty courts. And so we are glad to be able to work with them on some fronts. It has just impacted the way that our community members are treated and the outcomes of cases and their ability to receive the support and help that they need in order to not reoffend, to take that discretion away from the line deputies. Sorry for the long answer. Did I answer your question?
Thank you. Yes, Chair, I just would like a brief follow-up. Proceed. Thank you. No, I really appreciate that context and the larger explanation. I was drawn to your graph on slide 12. I know that new plea policy was implemented in December 2022, and then we see almost this exponential growth, almost doubling of the number of cases the next year and then even more the next. Do you believe that change in policy is what has resulted in this incredible growth in cases going to trial?
Thank you for that question. I do believe that it is a significant factor in that. I have heard it said that there's a COVID backlog. That certainly was the case for some time. However, I think the graph really says it all. And what I can tell you as a practitioner is that that's what we hear from our clients, right? They have a decision to make. And to be quite frank, in our criminal justice system, if every person arrested and accused of a crime wants a jury trial on a felony or gross misdemeanor charge, that is their constitutional right. It is not within our control to tell them you can't have a trial, or we can advise them about what's in their best interest, but it's ultimately our client's decision on what they want to do. And so what we see on a daily basis is when you take away the ability to negotiate and to take in the whole story into account, that's when people are more inclined to go to trial and see what happens. And I do want to add, we do receive offers eventually in some cases. Often it is after the pretrial motions have been filed and or completely litigated. And so I think that's why you're seeing also legislation about needing additional judges and staff to handle the amount of trials.
Thank you for that. Our next question will be from Assemblymember Gray.
Thank you, Madam Chair. For Clark County, and this is just a quick clarification, what is the alternate public defender's office?
John Puro for the record, Assemblymember Gray. We have a special public defender, and so what they do, and Washoe as the alternate public defender, and what they do is take the conflict cases. So sometime in this committee, you've heard me say it if you've been here for a while, sometime today's victim is tomorrow's offender. If we've already represented that person, we would have a conflict on the case, and the special public defender would have to take those, and those would be the Category A felonies for that.
Thank you for that. Our next question is from Assemblymember Gonzalez.
Good morning, and thank you all so much for being here. I was wondering if you guys could speak to the ratio of caseload that you have compared to the national trends and kind of like what are best practices. Thank you.
John Puro for the record, and I'm sure Evie could speak to this as well. The original study done on caseloads was done in 1973, and there was not another study until, 2023 that RAND came out with a new study, and the numbers are wildly different. I would say all of our attorneys are carrying over the recommended caseloads by ABA standards and by the RAND numbers. Our office, now that I got promoted, that's like a my problem thing, and our office is going to have to do a workload study to kind of do case evaluations and see what we can do to work with Clark County to hire more attorneys. And more social workers and more staff to support all of those things. That is one of the things with AB 66, that more judges bill. Like if that were to go into effect, we've ran the fiscal analysis, and we would probably put a fiscal note on that bill upwards of $13 to $20 million to hire additional staff to support those judges in those courtrooms. So it's something that we're going to have to work on, and I pass it over to Evie to say the same.
Evelyn Grosnick for the record. Thank you, Assemblymember Gonzalez. In 2023, the RAND Corporation, in conjunction with several organizations, came out with the National Public Defender Workload Study, and it's a weighted caseload study. So it takes into account the fact that some types of charges are more difficult to litigate. And so that's sort of the new standard. What it requires, though, is jurisdiction-specific data. And so that's something that has not been done for Clark and Washoe by an independent agency since 2009. At that time, the study that was done, I believe it was, I'm not sure who was really in charge, if it was the Supreme Court or the counties, but the decision was made to hold off on making an evaluation of exactly what numbers are needed, how short we are, those kinds of things. That decision was held off because they had just implemented ADKT 411, which imposed standards of practice for indigent defense. And so they wanted to give a chance for practitioners to start using those and then do another study, I believe was contemplated. That has not been done. We now have the Department of Indigent Defense Services in Nevada. However, recently those regulations excluded Clark and Washoe from data studies to determine. So that will be left to the counties, I believe, to figure out, exactly how they want to do that.
Thank you for that. Our next question will come from Assemblymember Hardy.
Thank you, Chair. And I do have a question this time. Thank you for being here, and good to see you, Mr. Pirro, and welcome, Ms. Guerrero. I wanted to go to slide 7, where you give the case numbers, and it is encouraging to see that in most of those categories, there's a decrease. So we're moving in the right direction there. I was just curious, in the misdemeanor category, that was almost 10% increase. If you could just talk about what some of those misdemeanors are that you're seeing increased. Thank you.
Thank you, Assemblymember Hardy. So, about 2 years ago, the resorts and the Justice Court got together and decided to do what's called a strip corridor court and focus on reducing crimes around the strip, which needed to happen in all candor. But what that focused on was a lot of homeless quality of life crimes. So a lot of trespasses, a lot of sleeping in public, sleeping on a park bench, sleeping on a sidewalk, vastly increased the number of misdemeanors that 2 courts within the county were taking. So we had to form, in response to that, our office had to form 2 specialty teams to do a strip corridor team. And then there's also an additional order out crime. So if you're homeless and you've lived your whole life in the tunnels, and I don't know if you ever spent any time with Shine a Light, but for anybody in Clark County, I highly recommend going with Paul Vautrinat and Rob Bankart, and I can help set that up for y'all. They're very good friends of mine, to go through the tunnels and kind of see how people are living in Clark County without the homeless resources yet given to them. What would happen is they'd go to jail, we'd house them at $250 a day plus for a few days, we'd release them, and then they'd go back to where they always lived. So that vastly increased the number of misdemeanors for quite some time.
And Paloma Guerrero for the record. I was on that team for the strip corridor court, and what you saw was just a rotating number of people. You saw the same people come in through every day, and it was all the same charges. When you went through that court, you were ordered to stay out of the strip, but that's where people lived, so they would immediately go back. And then they would have an additional misdemeanor charge of violation of the order out. So that's why we had that huge increase in just misdemeanors.
You want to follow up? Sure.
Okay, thank you. So then following along with all these things we talk about, trying to get people in programs so that it isn't just a cycle, has there been, or is there going to be an effort to like try and get those people into some programs so they aren't just going back out? And of course, this all depends on, their willingness and accepting that.
John Pure for the record. So although the courts and the Resort Association had agreed on standing up a court without services, because it was a court without services, so like drug court is a court with services, we started working outside through the Criminal Justice Coordinating Council. So when Ms. Guerrero talked about the Miami model, when I went to Miami, I was shocked at what I saw. They're 20 years ahead of where we are. And frankly, when they started that, they were right where we are. Like I remember when Assemblymember Roth was with the governor's office and we were trying to build an additional housing unit for competency people. And there's a judge in Miami, Judge Leifman, and he said, you cannot build your way out of this problem. You have to start doing diversion. And one of the things is, and it came before the legislature last year, I didn't look at the vote, I probably should have before this, was the Campus for Hope. So we have a lot of hope in our office that Campus for Hope is going to provide housing resources. When I became a lawyer, I had no idea the amount of community work we'd be doing outside of the courtrooms. But frankly, I'm very thankful that we do it. So as part of the Criminal Justice Coordinating Council, I sit on it with the sheriff and the sheriff's representative. Officer Hunt is on it with me, who's not here today. DA Steve Wolfson is on it, and what we're doing is trying to find solutions and working with social services. So Clark County, through Jamie Sorensen, if you have a chance to meet him, he's Clark County's Director of Social Services. He's amazing. His staff is amazing. And what they're doing is we're building a lot of those resources, so that's a place to go. It was just frustrating that when they stood that court up, they had no plan and didn't talk to us. Like we always say, come talk to us. We are very good partners. We want to find solutions. If you rope us in, I promise you that we'll find a way to work it out.
Thank you. Our next question is from Assemblymember Hanson.
Thank you, Chair. Thank you all for being here. And welcome. We have a Sparks High alum at the table with our new, so glad to have you here. Good to see you all. I had a question along the lines. First of all, I was so glad to hear that you mentioned one of my favorites, John Adams, a great public defender, even defended the British in the early beginnings of our country. So certainly a great way to get started in a new nation. I wanted to go to your slide 7 about holistic defense, talking about the likelihood of a custodial sentence being reduced by about 16%, and the sentence length, I guess, by 24%. I'm assuming that, and I get that. I mean, I think it is important. There's context in everything. Everybody has a story, and I do believe that it brings a lot to the table when it comes to the criminal justice system. And that's not to say that the prosecution doesn't consider that too, but it is important. So are we saying that when those reductions happened, the correlation is it was because either the jury or the judge was making a decision based with having that context? And I'm sorry, it was Washoe County's slide 7, at least when I look at it online.
Thank you, Assemblymember Hanson. Evelyn Grosnick for the record. Can I please just get clarification on the judge and jury part of that question?
So when we say that the custodial sentence by 16% and expected sentence length by 24%, was it a reduction by a judge or a jury because you used a holistic defense, or was it like a plea thing? Just a little more context.
I understand, thank you. Yes, so this was a study that was done with the Bronx Public Defenders, and as stated by my colleagues, they are sort of the leader in holistic defense. Our offices are trying to model that. And what they find is when you pursue alternatives to incarceration, including especially pretrial, and give people support and treatment and opportunities that they haven't had, they are more likely to be successful with following those rules. They're more likely to show the judge, I can do this if I'm given the right chance and appropriate support and treatment. And so I believe that's where those are coming from.
And Chair, just a quick follow-up to what she just said.
Go ahead.
Thank you. And so then I would wonder, what on the other end of this then, do we see what the percentages are on maybe they got this reduction and maybe that was a good thing, but then the outcome, was there additional recidivism at the normal levels, unfortunately, that we see? Or did we even see on that end a reduction in recidivism because they had been treated with a holistic defense?
Thank you for that question. Oh, do you want to go ahead? No, go ahead. Okay. Evelyn Grosnick again. I don't have that data.
If I may, Assemblywoman Hanson, John Pirro for the record. Again, as my colleague Ms. Grosnick said, this did come from a RAND study, and what they did was study a more traditional public defender's office like we have, Legal Aid of New York, but then the Bronx Defender is a public-private partnership, and they have attorneys that do family law, eviction law. So they had like a wraparound services. And what I could maybe compare this to is in law school, I was an educational surrogate, and I had a child under my care that was very mentally disabled, had schizophrenia. So he had a lot of workers, but one of the workers was a WIN worker. It was a wraparound worker. And what that worker's whole job to do was to coordinate all of us so that we were all on the same page and we weren't working in silos. And that's what the Bronx Defenders does, and that's what we're trying to get to. And when you have somebody like that, you have the housing attorney talking to the family law attorney, talking to the criminal law attorney, the results are better. The recidivism rate is way less, and they spend less time in jail. So it's a net positive for the community. It saves a lot of taxpayer money, and it stops people from re-victimizing other people.
Thank you for that. Our next question comes from Assemblymember Roth.
Thank you, Chair, and thank you so much for the presentation. My question is in regard to retail theft. So we heard from multiple agencies this week that crime is trending downwards, and that included theft crimes. I had posed a similar question earlier this week regarding the statistics that are provided from the state of Nevada. So that data is collected from the counties provided to the states, showing that theft has reduced since the passage of AB 236 in 2019. But there was a proposal regarding lowering the theft threshold. So my question is, what is the stance of the public defenders regarding the request to lower that threshold in light of crimes trending downward?
John Pierre for the record. One of the benefits of being here for my 5th session is got sort of a gray beard, and I can remember what happened in prior sessions. And so in 2013, organized retail theft only had an aggregate collection of 90 days. So with all due respect to Captain Josh Martinez, I can tell you that I've represented over 2,500 people in the criminal justice system, and not a ne'er one of them knew what the penalties were for what they were doing. They knew they were doing dumb stuff. There's, you know what I mean? But it's not like they were like, oh, I'm only doing this because it's this value, or I'm only doing that because it's that value. So what we did in 2019 with the passage of AB 236 was try to tie the value of petty larceny to the value of an iPhone, which I think an iPhone is probably even more than $1,200 now. And that was the thinking with the Criminal Justice Institute. But there have also been various other changes to the organized retail theft statute, which is NRS 205.08345. I'd put some thought into this because I had thought about this when the captain was talking. Last session, AB 50 came, and we increased the amount of people that could prosecute this. So before it was only local DAs, but we also allowed the AG's office to prosecute organized retail theft. And then in 2019, even though we passed AB 236, we upped the aggregate days that value can be shown. And I want to explain that. So before it was only 90 days. So if I went into Target and I stole, well, I'll use a case example, a PlayStation 5 controller. If some of y'all have kids who play video games, they're not cheap. Those controllers are like 60 bucks. And then I kept going back and kept stealing them and kept stealing them and kept stealing them. You could aggregate all of those amounts. So it wasn't just like, oh, I'm just getting off with a misdemeanor, off with a misdemeanor, off with a misdemeanor, off with a misdemeanor, slap on the wrist. You could aggregate all of those amounts to amount to felony theft. And that's for 120 days. So you can track me over 120 days if I'm continuing to do this behavior and to catch me doing that. So in long way of answering your questions, no, we don't think that the value needs to be lowered, especially with inflation going up.
Evelyn Grosnick for the record. I would just add, the more actions that you make a crime, the more crime you're going to see. So.
Thank you. Our next question comes from Assemblymember Gray.
Thank you, Madam Chair. The question, I'll give you the question and the backstory here real quick. How do people learn about the alternative courts? And the reason I'm getting at this is I have a good friend, neighbor, young kid, just salt of the earth kind of person, good dad, owns his own house, and he's just, barely 30. Got caught up in something a few months ago. And when he told me this has actually been going on for a while, when he told me his attorney wanted him to plead guilty to a felony because that's all the county would take, I was like, no, you got to be misunderstanding something. That's not the way pleas work or anything like that. And was just shocked. And the more I thought about it, I said, okay, if this is truly the case, tell your attorney. I mean, you're a veteran. He does have extenuating circumstances that I'm sure played a role in this. And, thank God he did go back, and I believe they got it moved into to Veterans Court. He was elated when he was telling me about it, but, he didn't know anything about it. Apparently his attorney didn't know he was a veteran, and there's different courts. So how do you guys line these folks up for that?
Thank you, Assemblymember Gray. Evelyn Grosnick for the record. Usually we try to find that information out about our clients, right? When we talk to them, we want to know the whole story. We want to know their background. I believe Washoe County has fewer specialty courts than Clark County, but we would absolutely want to know if somebody's a veteran. Now, depending on what they're charged with, they may or may not be eligible for those courts. And so that would be, but to directly answer your question, that would be part of the consult with the attorney, finding out that information and determining if they might be eligible.
And just to follow up, Angela Knott for the record, I've represented a few clients who have successfully gotten into Veterans Court. And with these individuals, what happens is when the first time you meet them, you look at the charges and you look at the fact that they don't have a criminal history or nothing. And that's the first thing that would pop in my mind is, why is this 30-year-old, why is this 50-year-old in my office? So I know there's got to be something more happening that someone with no criminal history is here. So that's when we start exploring more background information, veterans, substance abuse, mental health issues. And that's also where our social workers come into play. They can dig a little deeper. So a lot of the times that's what we're trying to do is figure out why they're in our office. And that should be one of our first questions to them.
If I may, just Assemblymember Gray, one of the things we have learned, though, is that, and I think a lot of people know this, the rural parts of Nevada are not getting the same services that the urban parts are. There's not the same amount of specialty courts, and we are the two major public defenders' offices in the state of Nevada. I believe Elko has a public defender's office, and I believe Carson City is trying to stand up their first public defender's office. the contract attorneys that handle criminal defense do not have the same resources that we have. They do not have social workers on staff that will help direct, you know. So as much as we're trying to do, and then sometimes it's not convenient for rural Nevadans either. Like, we have a law that says you can transfer a person to a specialty court in Washoe, but if they live where you live, how long of a drive is that to go 3 days a week? You know, it's not. Doing this for 5 sessions now, it's really time to start helping the rules come up to where they can help people. And if we're not, I've told all of you this before, like, we are a Band-Aid on the problem. We are helping people after somebody's been victimized. We are helping people after something bad has happened. We want to help people before that. Ms. Knott showed you the sequential intercept model. We've all spent the last 2 years kind of learning about that. And just as an acronym, it's like, and we're working with the police officers to do this as well, catching somebody at the 0 or 1, pre-charging, and saying, you're going through a rough time. Maybe we can direct you to drug support services, right? Let's not cut funding for those. Let's use our $1.2 billion in opioid funding to stand up a lot of services for Nevadans, including in the rural areas. One of the saddest parts of this job was a lot of the times we are the first people to recognize that somebody has a mental illness. And that means they went through their whole time in school feeling weird and alone and not helped, and then they've gotten into some amount of adulthood feeling weird and alone, unhelped, and that something is not right. And then here they are at 25 years old, and they're talking to me, and I'm like, I'm noticing something, so I'm going to send you to go see some doctors, and we'll get you a diagnosis, and we can get you on some medication that helps. Because a lot of times they're medicating with street drugs. My client told me one of the things that it has resonated with me and stayed with me my whole life. I have these voices in my head, and they are mean to me all the time. And you know, the only time they're not mean to me is when I'm using methamphetamine. That's the only time I get relief. The only time. And how long have you been suffering that way? I hate that it took this long for us to get you to help you out. But what I would like to do is do that before something bad happens, before somebody is victimized.
Thank you. Our next question is from Assemblymember Urick.
Thank you, Chair, and thank you all for the great presentation. I found it very informative and for really the work that you guys do. And I'll be honest, I didn't always appreciate as a police officer, but when I did go to law school and understood more the nature of our adversarial system and the absolute need for the work that you guys do in the Public Defender's Office. So thank you, and thank you again for the sharing of that holistic approach. I think what you guys are doing, you're making big strides that are helping what we do. I wanted to just offer this question to kind of counter, Mr. Perro, a little bit what you said, and not really in a direct confrontational way, but just to make sure we have this dais has a proper perspective on the issue of the theft issues and the raising or lowering of that threshold. You had indicated you had 2,500 cases. I don't know if all of those were directly theft related, but those significant number of cases where you never saw one case where somebody went in with the knowledge of, okay, I'm going to come in under this threshold so I can keep it as a misdemeanor. But to be clear, and I just want to make sure that everybody understands that in your role is already given in your presentation includes indigent defendants, folks that are facing jail time and folks that cannot afford an attorney. I think some of the testimony that we've heard and certainly some knowledge that I have about the district attorney's office and law enforcement in general are reporting an increase of theft rings, professional rings that are coming into our jurisdiction and committing crimes that do not have the need for your services, that are committing a significant number of these thefts. And I would, at least my understanding of it is that they are coming with full knowledge and are trying to leverage the felony misdemeanor distinction to get away with more. So I just hope that you might be able to opine on that or offer some comment on that perspective as well.
Thank you for that question, Assemblymember Urick. Evelyn Grossnick, for the record. We are not seeing necessarily a lot of that. I've heard the same things that you're talking about. There is a specific crime for organized retail theft, and so if that's something they're seeing and they want to prosecute, they certainly can. Our office has not noticed an increase. However, I have not collected data on that point. Thank you.
Just to follow up, Angela Knott from the Public Defender's Office. I handle a lot of our bail hearings on the weekends. And what I have not seen yet, any of the organized retail theft individuals coming in, what I'm seeing are people with very limited means going to Target or Scheels and stealing. One client had eggnog, stole eggnog and changed the sticker on a hat, on a beanie. They ended up with a $15,000 bail because the courts are seeing it and they're hearing the chatter, and so they're being a lot stricter, harsher on these individuals. And I see it to a point, but what's happening is they can't afford $15,000, right? They couldn't afford the eggnog. So then they're remaining in the jail. Their children now are with CPS because there's no one to watch the children. And I bring this up because it's been more than once I've had a conversation with Ms. Grosnick about it and what I'm seeing. So I think there's a balance there. So in Washoe County, we're not seeing the organized retail. We're just seeing people with limited means and then just being held in jail at the $200 a day that's going to taxpayers.
And Paloma Guerrero for the record. In Clark County, we do see these charges being brought forward by the prosecutor's office. So they are being prosecuted. I have had clients that have been charged with organized retail theft. So there is a means for them to prosecute that, and I've seen it. And those clients are indigent because they're getting my services. And even though we only get indigent clients, we're still in courts every day. And so we see everything that's coming through. And I personally have not seen these sort of more professional, sophisticated, organized retail theft rings.
Thank you. We have a question from Assemblymember Orrin-Licker.
Thank you, Chair, and thank you for your presentations and giving us so much helpful information on how we can improve our system and address the problem of over-incarceration. And I'm wondering if there's another area we should think about, and that is I've seen the research about the contribution of prosecutorial discretion in contributing to over-incarceration. Are there reforms we should think about that would address that problem?
Thank you, Assemblymember Orrin-Licker, for the question. Evelyn Grosnick for the record. That's a great question. Haven't thought about it for this hearing, so I don't think I have a great answer for you. But what I would say is we have a system built on the idea that we're trusting our prosecuting agencies to use their discretion. And so if that's not happening, then maybe we need to take another look. What I do want to say, though, the beauty of the sequential intercept model that both Washoe County and Clark County are using, the whole point of that is that we see people, we have contact with people who suffer from behavioral health issues at multiple points before and in the criminal justice system. It's about getting the right services to the right people at the right time. And so that has the potential, and the hope is to take people out of even the arrest phase, get them to a crisis center, get them set up with help and community resources, so we're not even dealing as much with incarcerating people for being an addict.
Thank you. I believe our final question comes from Assemblymember Gonzalez.
Thank you so much, Chair. I was wondering if you guys could speak to some of the barriers that people have attending court and kind of what are the consequences when it comes to missing a court date and or missing a mandated payment. Thank you.
Evelyn Grosnick for the record. Thank you, Assemblymember Gonzalez, for that question. some of the barriers are housing, transportation, working. A lot of people have to take off work to get to court dates, which can be, I don't know about Clark, but our court dates have their schedule. They know when things are set, and there's not always a lot of flexibility about time for court hearings. Sometimes, a client has to call in for work 3 times and then they're fired. And you're going to have probably more than 3 court hearings through the pendency of a case. Transportation, if they're too late, depending on the judge, they might get a failure to appear warrant, and then a lot of times they get scared. They don't want to get arrested when they come back to court, and so that can be a barrier as well. So I would say not having supportive housing, when you're living in the tyranny of the moment, you're not as worried about court as putting food on the table or where you're going to sleep that night, or taking care of your own physical safety. So housing, transportation, physically getting to court. We don't have the best public transportation in Northern Nevada. And there was a third one. Now I just went blank. Thanks.
John Pierre for the record. Same issues in Clark. One of the things that we are working on with the Criminal Justice Coordinating Council and the Department of Social Services is using the supportive housing resources and coordinating transportation. And that comes with a good partnership. The assistant sheriff in charge of the jail in Clark County is amazing, Fred Haas. And sometimes jails will let people out at 2 a.m. in the morning. And good luck getting to where you gotta go. It's not gonna work. So what we're trying to do is stand up transportation directly to the supportive housing, and then focus on transportation back to court for court dates.
All right, thank you for that. And with that, not seeing any more questions, thank you so much for your time and for your responses. I know there was a lot of questions, but important for everyone to get this, not on the record, but really just for our own understanding and such. So I appreciate your time. With that, I will go ahead and close this agenda item. And our next item for today is public comment. So again, we will take public comment first here in Carson City, then we'll move to Las Vegas if there's anyone there physically that would like to make public comment. Those who will make public comment by the phone, the number today is 1-888-475-4499. When prompted, please enter the meeting ID, which is 869-7021-4603. And with that, I will first welcome anyone here in Carson City that would like to make public comment. Not seeing anyone. Is there anyone there in Las Vegas that would like to make public comment? Also not seeing anyone. Broadcasting, will you open the lines, please?
If you would like to provide public comment, please press *9 now to take your place in the queue. Caller with the last 3 digits, 037, please press *6 to unmute your phone. You may begin.
Tonya Brown, TONJABROWN, Advocates for the Inmates and the Innocent. Good morning, Madam Chair, members of the Assembly, and want to say thank you for the great presentations to the presenters. It's kind of interesting what was being said today. I don't know if some of you don't know how far we as advocates have gone back in helping get some of these laws created, and as a stakeholder in 2017 with AB 510. There was a lot of issues with that. In particular, most of you know that I kind of work with the inmates and I work with the innocent. There was a lot of those who have claimed innocence when they would appear before the parole board. The parole board would let them know you have to admit guilt or you won't be admit guilt and ask if they were appealing their conviction. And that became part of AB 510 back in the day. And so I've had the opportunity over the years to go to the parole boards and to attend meetings and hearings, and to see how some of these inmates were treated in some of their parole hearings. But a few months ago, I actually attended one who had maintained his innocence. And the question came up about appealing his conviction, which they're not even allowed to consider, yet they were asking about it. Fortunately, now he is going to get a new rehearing on this. But I suggest sit in on these parole hearings and the meetings, and you'll get some good information on the way people and the parole board are treated. For an example, only private citizen at the time to get in for that hearing. And yes, he was treated differently than the other inmates. And when you're maintaining your innocence, even to this day, despite AB 510, they're asking questions about your appeal, and it shouldn't even be considered.
Ms. Brown?
I just would like to let you know.
Ms. Brown, we're over our time. Ms. Brown?
Okay, well, thank you.
Thank you so much. Thank you so much, Ms. Brown. You as well. Have a great weekend.
You're welcome.
Next caller, please.
Chair, the public line is open and working, and there are no other calls to testify at this time.
Okay, thank you so much. With that, I will go ahead and close public comment. Just want to remind everyone that we are agendized every day, Monday through Friday at 8 a.m. Obviously, sometimes there are some days where we may be able to, modify that schedule. Disappointed to tell you that if the Lions were in the Super Bowl this weekend, we would not be here on Monday morning at all. But somehow they're still going on with that game. And so I don't know why, but apparently they are. But with that, on Monday, we will start at 9 a.m. So for those of you who choose to celebrate anyways, we will start at 9 a.m. So everyone have a great weekend. That's the business. We've concluded, and this meeting is adjourned.